Okay, my name is Jeff Morgan. I'm from Dallas, Texas. The reason I'm making this video and the others in this series is because I'm supporting Matthew Krause in his efforts to repeal no-fault divorce in the state of Texas. One of the things that people think about when they think of no-fault divorce, they think that two people get together and they just want to part ways and everything's going to be happy and, you know, it's better after all because if there was conflict there, we can get rid of the conflict. It's probably better for the kids. No-fault divorce is a nice, easy way to say, you know what, no harm, no foul, just didn't work out. The commonly used terminology in the state of Texas is that it's insupportability for the causes of marriage or irreconcilable differences. That, in the majority of instances, is a myth. By nature, no-fault divorce is a legal action brought against somebody. And in many instances, one person who wants out of a marriage is bringing the action against another person who is going to be forced out of the marriage. So basically, this is a contract between my ex-wife and a law firm, Schoenberg and Grimes PC, which will be known as the firm. And this is the contract and agreement regarding the firm's representation of my ex-wife in two family law-related matters filed or to be filed in district court in Texas. The client, my ex-wife, understands the following conditions regarding employment of the firm in this case. Number one, the date of actual employment of the firm is April 25th, 2012. Number two, no representations have been made by the firm as to the ultimate success of the case, and the only material representations made by the firm to the client are that each firm member will exert his best professional efforts in the representation of his client. There have been no guarantees made by the firm that there will be a recovery of fees, costs, or expenses incurred by the client in the cause of this action. Number three, the client fully understands that this instrument represents a contract for services rendered and to be rendered by the firm, and that such services are conditioned upon the term of this agreement, including but not limited to payment for attorney fees to the firm in accordance with the fee schedule and other fee terms set herein. Number four, the client fully understands that the firm accepts no responsibility or liability of any nature for any matters related to this cause which precede the date of this agreement. Number five, the client fully understands that there is a minimum fee deposit of $2,000 which has been paid on today's date and a minimum cost deposit of $323 which will be paid on or before May the 9th, 2012, which is in no part refundable, although time expended on your behalf will be credited toward this fee. The minimum fee deposit is based upon the perceived complexity of your case. The likelihood that acceptance of your case may preclude us from taking other cases to ensure this firm's availability to your case and the skill and expertise of the particular attorney who will be responsible for your case. Number six, the client fully understands that such minimum case fee deposit is absolutely vested to Schoenberg and Grimes PC upon execution of this agreement. Number seven, the client understands that the fees in this matter may well exceed $2,000 and costs may exceed $323. Number eight, the client fully understands that at such time as the minimum case fee referred to in paragraph 5 above had been expended, the client shall be required to make an additional trust deposit or maintain a current balance with the firm at the attorney's discretion. And remember, this is the contract for services from the attorney, and this is in the instance of a no-fault divorce. No-fault divorce. I would hate to see a more complex divorce. Number nine, the client fully understands that upon the case being set for mediation, unless if the arrangements are specifically made in writing, the firm requires any past due or billed or an unpaid fees and expenses to be brought current. The firm requires a $4,000 retainer balance for a full day of mediation and a $2,000 retainer balance for a half day of mediation. No-fault divorce is making divorce cheaper and easier. Any retainer remaining at the time of mediation has been set may be applied toward the mediation retainer. The mediator's fee because there's a fee involved in this as well. There's a mediator who has to pay a fee, is not included in the mediation retainer and must be paid in full prior to the mediation. Number 10, the client fully understands that not less than the first day of the month prior to the month in which a trial of this cause of action is set, unless if the arrangements are specifically made in writing, the firm requires any past due or billed and unpaid fees and expenses to be brought current, and a trial deposit to be made in an amount not less than the amount determined by multiplying 8 hours per day by the attorney's hourly rate as provided herein for the number of trial days estimated by the firm. Number 11, just to be perfectly clear, we do not represent clients on a fixed fee basis. Any figures quoted as to the total cost of our services are merely estimates based on stated hypothetical occurrences, and they cannot be relied upon as an accurate estimate. Your adversary, well, wait a minute, I thought this was a no-fault divorce and everybody was going to be happy. Oh, your adversary, the opposing attorney. And I'm not sure if your adversary is your ex-spouse, want to be the person who you are suing, and the opposing attorney is somebody else, or whether the opposing attorney is the adversary. But your adversary, the opposing attorney, or others may engage, oh, your adversary. This is the person you are suing for no-fault divorce. He is now called your adversary. This is in the agreement from Schurenberg and Grimes with my ex-wife. Your adversary, comma, the opposing attorney, comma, or others may engage in activities requiring us to expend additional time not originally contemplated. Number 12, the client fully understands that the firm may withdraw from representation in the event client A insists upon presenting a claim or defense not warranted under existing law and which cannot be supported by a good faith argument for extension or reversal of such law. B, personally seeks to pursue an illegal course or conduct, because these attorneys are so ethical, they don't want to be involved in anything unethical or illegal or anything along those lines. C, requests that the firm pursue a course of action which is illegal or prohibited under disciplinary rules. Now remember, this is no-fault divorce. We're just going to have it nice and easy, and everybody's going to leave and get on with their lives, and it's going to be cheaper, and everybody's going to have the parents will split, and the kids will be happy, and everybody's going to be happy, and the attorney's going to make a boatload of money, buku money, I should say. D, by other conduct renders it unreasonably difficult for the firm to carry out employment. The employees, yes, okay. E, insists upon the firm engaging in conduct which is contrary to the judgment or advice of the attorneys. I wonder why that might be. They're trying to do things to increase the bills and to also win, of course, to win for their client, but don't think that they don't have their self-interest involved here in how to increase their fees. And I can go into that in a different video. F, disregards an agreement with the firm as to fees or services, costs, or expenses rendered. This is before we engage the attorney to represent us in a no-fault divorce. Now let's go to the fee schedule, because part of the contract and agreement must include the fees. The fee schedule. The firm and client understand that the following fee schedule shall apply as a condition of employment, and that client accepts full responsibility for the payment of all balances due for the legal services as follows. Number 1, all trial and non-trial time expended in connection with this cause shall be charged at the hourly rate set forth below. Wait till you get a load of this rate. Non-trial charges include, but are not limited to, telephone conferences, interviews with the client or other parties in connection with this cause, legal research time. Legal research time, this is a bunch of garbage. It's a no-fault divorce. You don't have to have any legal research to speak of in a no-fault divorce in Texas. All you have to do is say that you want it and you get it. But in case there is some legal research time and drafting of legal instruments, of course, those are already pre-formed out and you just fill in a few words and print it off. Preparation for court, review of correspondence and documents, and miscellaneous time spent in office practice and or legal investigation. no-fault divorce and we're having to deal with a legal investigation, because the nature of no-fault divorce, the real nature is not two people getting together and deciding, hey, by mutual consent, we're going to split. The majority of cases are lawsuits. You are being sued. Trial, and this, now we get into the trial time. Trial time, number 2, trial time includes times in courtroom attendance, whether an actual trial of this cause or at ancillary hearings or motions, such as motions for contempt. Motions for contempt. These are really good. We can bill some big bucks with motions for contempt. Number 3, all case expenses, including subpoena costs, filing costs, disposition costs, accounting costs, investigation costs, experts' charges, no-fault divorce, you've got to get the experts out there, of course, delivery service costs, Xerox and certified copy costs, computer disk rental, and all other miscellaneous actual expenses incurred in connection with this cause are due and payable by the client as incurred and will be paid from the trust account disposition so long as such is available. Number 4, all time will be recorded in units of 1/4 hour. That's 15 minutes, even though the time spent may be less than a quarter hour. So if you make a quick phone call and you talk with the attorney for a minute or so, guess what? You got a 15-minute charge, quarter hour charge. But wait till you get to the kicker of how much it's going to cost you for an hour. Number 5, all accounts are due and payable in our Dallas County, Texas. Unpaid fee balances owed to the firm as well as expenses advanced on behalf of the client shall bear interest at the rate of 12% per annum commencing 30 days, that's 30 days, after the date of the firm's representation of the client is concluded. Such interest shall appear on each statement. So in addition to representing you for basically no cost and gouging you for interest, but remember, the family law attorneys are there to fight for you, and that's why they want to preserve your right to no-fault divorce, because they would hate to see their cash cow go away. And now we come to the miscellaneous. Number 1, this contract and agreement does not include presentation of the case to any appellate court. And in any event an appeal is necessary, client and attorney will consider the appeal as a separate and distinct cause of action requiring new fee arrangements. Number 2, our representation does not include rendering tax advice to you. Good. You must seek such advice from your accountant or other financial advisor. I'm just wondering off the top of my head, I wonder if they have certain agreements, we get this, if you send somebody to us, we'll make sure to send them back to you, and we'll keep the fees going back and forth between each other. I don't know, but just one of the things that a normal human being might wonder. Money corrupts, and money corrupts absolutely in a lot of instances. You must seek such advice from your accountant or other financial advisor. We may, however, provide you with a tax analysis of fees, which may be tax deductible. How sweet. And now the kicker. The billing rates. This is for no-fault divorce because, the two people just wanted to split up their marriage and just go their separate ways. But we've got to get the attorneys involved. We need the attorneys to make sure everything is done legally and right. And it doesn't make a difference whether one person doesn't want the divorce or not. We need to get the fees in here, the billing rates. The firm and client understand that from time to time, during the pendency of this cause and the firm-client relationship, that firm may deem it unnecessary to use the services of legal assistants, paralegal employees or other associates, and client agrees that use of such is acceptable to him or her in this instance, because this was actually for my ex-wife, not for me, and that all work performed by assistants selected by the firm shall be fully supervised by Charles E. Schurenberg and/or Gary Ullman Grimes, and that periodic time spent, if any, by legal assistance shall be billed at the following rates. Charles E. Schurenberg, $400 an hour. Gary Ullman Grimes, $400 an hour. A paralegal, well, at least you get a break on this one. Paralegal is only $125 an hour. Law clerks are only $100 an hour. But, our billing rates may change in the future. Often family cases pend as long as 12 to 24 months. Now this is no-fault divorce. Maybe the contract wasn't specifically written for no-fault divorce, but this is the contract that you have to sign because you're going to get one of the most ethical attorneys in the city of Dallas to represent you in a cause that you actually told him you were at fault for, and in which you told him your husband is one of the best men that she knows, but you're going to sue him for a divorce because of something that you did, and we're going to say that it was insupportable. It was a no-fault divorce. How sweet. Family cases often pend as long as 12 to 24 months. If our hourly rates change, and you know they could, they're probably not going to go down, but they could go up, you'll be notified approximately 30 days before the change takes effect. I just wonder, you know, and I'm not saying I'd have no idea how this works, but I mean, if you have say an 18-month case and you're 12 months into it, would that not be a good place to see some billing rates increase? You've done all this work and you've got nothing. I mean, now you're beholden to the guy, right? And why not? Hey, maybe it would go up to $450 or $500. I don't know. But I'm just saying, I'm sure that nothing is beyond the imagination of certain folks who think that they need to earn their living by destroying families and basically telling their client it's okay, even though you told me it was your fault, the divorce was your fault. In Texas, we don't believe in that. We believe in no-fault divorce, and by God, we're going to string him up by the balls. Notice the client. The State Bar of Texas, the ethical part here. The State Bar of Texas investigates and prosecutes professional misconduct committed by Texas attorneys. Nothing here so far, you know. Although not every complaint against or dispute with the lawyer involves professional misconduct, the State Bar's Office of Chief Disciplinary Counsel will provide you with more information about how to file a complaint. Please call 1-800-932-1900 for more information. Signed, April 25th, 2012. My ex-wife, who is the client. And then Schurenberg and Grimes PC, it's signed by Charles E. Schurenberg. So, no-fault divorce. Two people just getting together, deciding to split their separate ways, and life goes on. No-fault divorce is one of the worst pieces of legislation that has been passed in the state of Texas. Ranks right up there with allowing abortion, in my opinion. And you take good people or innocent people and you try to criminalize them. And even if the person is at fault for the divorce, you claim that they're not really at fault, it's somebody else's fault, and you get to plunder their assets, their money. In fact, it's interesting because usually when you see an attorney, what do? They want to get your financial statements. And I think part of it at times is to find out how much they can take you for. Now, I may be wrong in that, but that certainly is the impression that I get from these wonderful family law attorneys who are there to help defend your right to no-fault divorce. And I support Matthew Krause to repeal no-fault divorce in the state of Texas.